Yes, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted. Glad to be with you here. And I got a major tech issue for the show for this week. It's live from the Fortified Compound in Mesa, Arizona, November 4th, 2017. I'm glad to be with you here. A lot of stuff to get to. I did not get to discuss on the big show on Wednesday. And yes, we will be live on Wednesday. Another thing to get out of the way here at the beginning of the broadcast is Libertopia 2018. It is back. I think they've been gone for 2 to 3 years. Let's say 2 years. Certain about that. And Libertopia will be back again at Humphreys Concerts by the Bay and Hotel on Shelter Island in San Diego. It's going to be the weekend of May 3rd through May 6th. So definitely check that out. We got plenty of time to get tickets and get set up. I have been asked to speak again, so I'm looking forward to that. And should be getting a jam with the guys with Barnwell Swift. You know, this Bill from the Living Tea Brewing Company in Oceanside, California. So looking forward to that. So I got to keep track of Skype a lot more now. Yeah, I know I was supposed to blow it out, dust it out. Oh, okay, so anyway, what do we get here? Yes, I wanted to talk about some calls that we had gotten from the... I made some tax calls, which is a very common thing, but this one, it was a state or kind of a county issue up in Northern California, and it had to do with property tax, and they're trying to tax a mobile home up there in Northern California, and so we made some initial calls. I actually got 2 professional men on the line, which is really refreshing. Usually it's the IRS, and I have an IRS call that we'll talk about also with that. So I got to speak with a nice gentleman. And look, and this is computer generated from what they've told us. This is probably the first time there's been some human interaction regarding this. But I'm talking about this because it's very instructive on how effective the Socratic method is, and why we use that. Why, instead of just making claims, we use the Socratic method of just asking questions to bring out contradictions. Basically, in a nutshell, you tell me you believe that X equals Y. You tell me why you believe that that's true. What is your reasoning that led you to that? And are there any contradictions? And is it really a valid claim? So the first guy I had spoken to, lower level guy, just someone who happened to pick up the phone. Because all we wanted to do initially was to set up an informal hearing to dispute the assessment. And the assessment isn't asking for a whole lot of money, but it is something that's based on principle, which is why we're doing this. It's not a lot of Socratic method dealing with property taxes. What do we do here? And I don't release the recording because the guy's right in the thick of it, and I don't want there to be any trouble. So even if I bleep out the names, I'd rather not take the risk. He's doing it on principle, but he doesn't want to be fake. He doesn't want to, he doesn't want to make waves. So, which is on the side, hey, that's fine. Plus, if you're in the middle of it, it could make it more difficult for you. So, all right. So, one of the things we need to do is we need to get them to confirm their position. Pretty basic. We want to know what their claim is and why they believe that. So we have to ask them to confirm what the claim is. Remember, we're just asking questions. And I know, in the middle of this, especially when it gets heated, like with my call with the IRS, the natural inclination is to just tell somebody that they're wrong. And no. If you just ask questions, and yeah, your questions have to be pretty focused and direct, but if you're asking just effective questions, you're going to be a lot more effective in getting your problem resolved. And here, this is a property tax. So I have to have them confirm what their position actually is. So you're operating under the presumption that if the property or I am physically in California, then your Constitution would apply, and that's the basis of your jurisdiction to do an assessment. And he says, well, yes, of course, that's the way it all works, whether it's in California or Arizona or somewhere else. Like, all right, great. We appreciate that. So, and this is what I do is you always want to write down that you've got such a confirmation. So you want to be able to go back to that. And as you're going through the process, when you want to be able to go back to their answers because you're trying to bring out contradictions. So we'll continue with that more in just a few moments. And if you want to reach me, it's Frank Rizzo 3 on Skype. Yes, welcome back to the No State Project. I'm Marc Stevens, author of Government Indicted. Glad to be with you here from the Fortified Compound live for November 4th, 2017. And we'll be live on Wednesday, so definitely check out the Wednesday broadcast. Hey, so what I was talking about before, and I'll give the other number out later. What I was talking about a call to a tax agent, and it doesn't matter that it's income taxes or it doesn't matter. The foundation of the claim, whether it's income tax, sales tax, or property tax, it's always the same thing. You're physically in California, our laws apply. That's okay. So that's how we start. We want them to confirm that is how they are operating. So he confirmed. This gentleman confirmed that, yes, they do operate under the presumption that if you're physically in California or the property is, their Constitution and laws apply, and that gives them jurisdiction to do an assessment and require you to pay some funds. So keeping it simple, I start asking my questions to see, look, why does he believe that this is true? And I had asked if there is an erroneous assessment, you do have the authority to abate it or to vacate it, And so he tried to say, well, no, it has to go through the appeal process. And again, just asking questions. I said, so you're telling me that if you're confronted with an assessment that is erroneous, that you're going to force the individual who you falsely assessed, you're going to force them to go through the appeal process? Why would you force them to go through the appeal process instead of just dropping the assessment? So he tried to come up with different ways why it could be erroneous. So look, just in a general sense, without committing to anything, just in a general sense, if you've got an assessment that is clearly wrong, that you had no basis for, wouldn't you throw it out? He's a nice guy, but they have this thing. It's so difficult for tax agents to even conceptualize that one of their assessments could possibly be wrong. That's the way the Franchise Tax Board is. In fact, the Franchise Tax Board are some of the worst bureaucrats I've ever encountered. They are more resistant to the idea that they could make a mistake than even the IRS. Even the IRS agents, like I'll talk about later, even they admit they could be wrong. Well, yeah, of course, and if it's wrong, then we will, we'll reverse this and we'll reset it or we'll throw this out. I had one on the East Coast a few years ago where the IRS acknowledged that based on the information that we had sent, that there was no obligation to file a return. So they admitted they were wrong. Not so much with the Franchise Tax Board. So just get in a general sense. Look, generally speaking, not in this particular case, but in general, just regarding your policy and your procedures, if you have an erroneous assessment, then you can throw it out and without forcing somebody into the appeals process. Thank you. Yes. Very important to get that. Because you want to be talking to a gatekeeper, someone who at least knows what the process is. No point in talking to somebody where you could show it's an erroneous assessment, but they can't do anything to throw it out. So get to a gatekeeper. So then you are now in the next part of the questions, which is going right for the throat. Right for the throat, especially if you're in court because you don't have that much time. When we do this on the phone, we don't have much time either, although I think we were on the phone with this guy for about 15 minutes. Yeah, about 15 minutes. So, the big question is, all right, you believe that just because the property is physically in California, your Constitution, a written instrument from 1879, somehow applies and gives you jurisdiction. Now, do you have any evidence whatsoever, any proof at all, that would prove that that claim is true? And you get those long pauses. Well, the property is in California. Yeah? So remember, you're just asking questions. Don't say to him, you're just repeating your claim. That doesn't count as evidence. You put it in the form of a question. It's 100 times more effective. And you ask him, aren't you just repeating your claim? And what do you mean? Well, your claim is that if the property is physically in California, your Constitution applies and gives you jurisdiction, right? Yeah. I asked you for evidence that that was true. And you said, well, the property is in California. Isn't that just repeating your claim? Now the wheels are starting to turn in this guy's head. He starts trying to talk about, well, there's Proposition 8, and then there's Proposition 13. I said, okay, are those parts of the Constitution? Well, yes, and they were passed by some referendum or some proposition, submitted to a vote. I said, okay, but is it part of your Constitution? Well, yes. So by quoting a section of the Constitution, is that answering my question or presuming that your claim is true? Again, just in the form of a question. It's much better to ask a question than just tell somebody that they're wrong. Because telling a bureaucrat they're wrong, only thing it accomplishes is, well, it wastes your time, and it gets them to dig their heels in even harder. Nothing probably makes a bureaucrat more upset than being questioned and told that they're wrong. Don't tell them that directly that they're wrong. You do it in the form of a question. So he continues trying to hold, but the proposition, and it was passed. I said, I understand. But aren't you presupposing that the Constitution applies if you're going to cite the Constitution, a particular section? Well, okay, so again, what evidence, if any, do you have that proves that just because the property is physically in California, that a written instrument from 1879, your Constitution, applies to it and gives you jurisdiction? And that's when, and he was nice about it, that's when he bailed. That's when he was saying that he is not, he says, you're going to have to speak to my manager or maybe even counsel because you're going way beyond what I can discuss. But before he did that, see, I got that music. We'll be back here in just a few moments on No Stay Project. Don't go away. And Frank Rizzo 3 on Skype. So before the agent actually, I'm looking at my notes, before the agent actually decided he was in over his head, he did use the D word. And this actually is what led to him not wanting to discuss it with me anymore because he was out of his league. And what he said was that I was debating the constitutionality of propositions. He was I was debating, and when I pointed out through just asking questions, am I really debating if I'm just asking you for the evidence? So this is why I said you write down what answers they give you so you can go back. Well, didn't I just ask you if you operate under the presumption that if I'm physically in California, your laws apply? You said, well, yes. And didn't I just ask you for the evidence that it was based on? Well, yeah. And didn't you just repeat your claim and then move on and actually cite the Constitution? Well, yeah. At what point did I start debating constitutionality? Am I just asking you for evidence? Well, yes. And then realizing that he wasn't going able to divert attention away, and he wasn't going to I was not going to allow him to give non-responsive answers. That's when he threw on the towel and decided that he was going to have his supervisor call me back. This is a very common tactic that people will take with you. I'm not going to debate the tax laws with you, sir. All it is a way of, and I don't know if this guy was necessarily showing bad faith. I didn't get that from the guy. I just thought it was a desperate attempt to get out of a very difficult situation. I think most of the time it is just a scumbag move by an agent who doesn't like being caught with an unsupported claim. So then they have to distract or deflect the attention away from their lack of evidence, their lack of good faith, and they have to deflect the attention away from that. They have to put it on you as if you're doing something. Well, the guy's just debating. And this is why it's very important that when you do you do get an agent that says that the supervisor will call you back, you want to make it very clear in your notes. It must not say that I called and I was debating the tax laws with you. You cannot do that. That would be in bad faith. Now, the fact that most of the time that they do call back leads me to believe that sometimes they are actually being honest and they're not putting in the note, this jackass was just debating the tax laws. Because if they see that, they're not going to call you back. They don't want to debate the tax laws. The courts have ruled most of the time that the tax code is constitutional. But that's a straw man. We're not talking about that. We're not debating. We're just asking questions. You say, but you are debating because you don't believe that they have the evidence. Well, let's discuss the lack of evidence. Don't turn around and say I'm debating constitutionality, because that's not what's happening. If there is a debate, if there is a discussion going on where there are opposing claims, it's on the fact that they have no evidence, not because the proposition is not constitutional. So don't straw man that stuff. Okay, so the supervisor actually does call me back, not very long after we were on the phone, and this was quite a call. This guy, he didn't attempt to say that I was debating the tax laws. He realized really fast that he was in way over his head. I want to quote him here. So I walk him through the process, which I'm not going to go through again right here. But I walk him through the process, tell him, what happened, and I get him to confirm that, yes, they do business under the presumption that if you're physically in California, then the Constitution and Code apply to you, and that gives them jurisdiction to do an assessment. So I was really surprised. I'm gonna call him, Robert, and so he agrees that they do business. That hey, if the property is physically in California, then the Constitution and laws they apply, and we have jurisdiction to it. So then I asked him what evidence, just like I had. Why I was talking to him in the first place, because his subordinate was not able to produce any evidence to support the claim. I asked him, hey, do you have any evidence to support the claim? And he tried, again, to go with proposition, and I corrected him on that by asking a question. And I said, look, I just want some information. Now, without repeating the claim that if you're physically in California, the laws apply. We already know that's your claim. Without repeating that, do you have any evidence to support that and to prove that claim is true? And I love what he said. He said, you stumped me on that one. So I said, I gotta write this down. You've stumped me on that one. And he stated that he just couldn't answer that. And he said, well, so now we've got two employees who are sitting on an assessment, and they can't prove that it's true. Wouldn't it be prudent to at least put the brakes on and not escalate this matter until such a time as someone down there can prove the claim is true? And he agreed that we could do that, but he wanted to have his supervisor or counsel call. Now, unfortunately, that took place on Wednesday, November 1st, And today's November 4th. Yeah, I did not get a call back. So I'm still waiting for a call back on that one. We'll see. We'll see. I mean, he seemed like a nice guy, and so he was the supervisor callback. So we'll see. I'm sure he went back, and I'd love to hear a conversation like that. I said, man, I don't understand this. I've never heard anything like this before. The guy's calling up, and it sounds simple enough. He knows. He's done this a lot of times. He asked me if the property's in California that. Do the laws apply, and that gives jurisdiction for an assessment? And I said yes, and he said, well, yes, and that's just the way it's done. I didn't include as part of it, but I'll throw up, because one of the things that they look at is, well, that's just the way it's always been done. You know, they both pulled that. I'm like, well, but this is just the way we do it. Oh, okay. It sounds like you're making an appeal to tradition. Do you think that your claim is true just because you've done it this way? Well, no. So there still has to be evidence. Well, yeah, evidence that neither one of you can provide, and it's got to be bewildering. Where, I mean, imagine you're doing this for 20 years. Some of them have proudly proclaimed to me, "I've been doing this for 25 years." And imagine that some putz from Long Island calls you on the phone and says, hey, do you have any actual proof that that's true? And are they required to have evidence? Well, even under their own rules. Yes, due process, fairness, these principles. The decision shouldn't be arbitrary. It should be based on evidence. Evidence does not consist of, well, this is the way we've always done it. That's just your garden variety appeal to tradition. Oh, not evidence. It is not information proving that the proposition is true. We'll be back with your calls. I'm going to start taking some Skype calls after this break. And I'll get back. We will talk about the IRS. But if you want to reach me, instant message me on Skype at Frank Rizzo 3. And we'll be right back with those calls, so don't go away. Yes, welcome back to the No State Project here on the Liberty Radio Network. That's LRN.FM. It's November 4th, live from the Fortified Compound in Mesa, Arizona. Remember, May 3rd to May 6th, 2018 will be the Libertopia back in Humphreys Concerts by the Bay in San Diego, and you'll get to hear me speak, and also I'll be playing some guitar with Barnwell Swift. We'll hopefully get a jam going there. I think we got enough time to actually plan that. So definitely sign up for that. You go to libertopia.org and get registered and set up today. Because my caller line is screwed up, you can reach me here at Frank Rizzo 3, but instant message me first. And then I can get you up on the big show. Even if you instant message me first and I can call you on the phone, I can do that on a break. I can call you and bring you up that way if there's an issue with Skype if you don't have a headset. So we will get through this one way or another. You can still instant message me at Frank Rizzo 3 if you have a question or comment for the broadcast, but you don't want to or not able to come on the air. One who is able to join me is Trevor, so he's on Skype. So Trevor, welcome to the No State Project.
Thank you, Mark.
It's good to have you. I'm sorry, where are you calling from?
Portland, Oregon.
Portland, Oregon. Well, what's going on?
So I got your packet, sent it in, a motion to dismiss and discovery request, Brady request for a photo radar ticket. Their only response was a fee schedule for traffic violation discovery at this point.
That's great. Wow. Not
so
too subtle.
And of course, court is going to be on Wednesday, Thursday. So I've been practicing listening to everything I can get my hands on with you. And I feel like I'm pretty prepared. I've got, 15 or 20 questions I can ask prior to the proceeding itself. But wanted to obviously consult with you just real briefly. Do you feel that it's best just to ask for any facts or evidence that the prosecution or plaintiff has submitted that would allow the court jurisdiction, or do I go through the questions first?
I would go right for the throat. They haven't ruled on your motion to dismiss, right?
No, sir.
So that's the first thing right out of the gate, the motion to dismiss. Got to resolve that somehow, either grant it or deny it before going to trial. That's kind of the way things work. And for those who are new, and we appreciate you tuning in, just know that if you were to sue them, you'd find out that that is actually the rule. They have to rule on the motion prior to any kind of trial. And if you were suing the judge, there's no way in the world that that they would wait to trial to rule on the motion to dismiss for lack of evidence proof or lack of jurisdiction, because that's not how it works. You rule on the motion first. It's called a pretrial motion, and it's that for a reason. It's probably not considered criminal, though, right?
No, I believe it is a civil matter. That was one of the questions, is if it's a civil matter or a criminal matter, and then is it adversarial?
Right. But do you know? I mean, do you know for sure that it is civil at this point?
I'm about 90% sure that's the case.
Did you have an arraignment, or is this just the first time you're going in there for a hearing?
This is just the first time, so no arraignment as of yet.
Yeah, unless they said it was an arraignment, then if you're going into trial, then yeah, it's probably considered civil. So the Brady material isn't something. Brady isn't applicable, but still the information that you're asking for is still applicable, because the prosecution still the rules of evidence don't say criminal rules of evidence and civil rules of evidence. They are the rules of evidence, and they apply to both. And the necessity to have a qualified witness it doesn't matter whether it is civil or criminal. So whether you call it Brady or not, they still have to tell you whether they have competent witnesses that they're calling. And if they're knowingly calling an incompetent witness, they have to disclose that. It's called, it's part of what's called their due process, they tell me. So I would go straight into the motion to dismiss and seeing if let's see how prepared you are. What if you bring up that fact and a judge says, hey, okay, do you have anything to add to your motion, sir?
Well, in order for me to continue, I do need an answer to the question.
What was the question?
Question was, I did submit a motion to dismiss, so I just need a decision on that first.
Well, and the judge may turn around and say, do you want to add anything else to your motion?
Not at this point, no.
Yeah, you see, that's why I asked that question. Never fall for that. What should you say when the judge says, do you have anything to add to your motion?
Is that where I'm asking for any facts or evidence to support the claim?
Yeah, that's what I do. So, yeah, so the only thing that I have here right now is I want to know if the prosecution has any evidence to support their claim that your Constitution applies to me just because I'm physically here in Oregon. That's what I want to know. That's because it's the only way that can overcome the motion, correct?
Correct.
Well, I'm sorry, I want the judge to say that. I want the judge to say correct.
Okay.
Because your motion to dismiss, as you've read through it, is based on a lack of evidence, right?
That's right.
There's only one particular section that is not necessarily a lack of evidence on part of the prosecution, and that's the last one, that the jurisdiction of the court is not expanded due to any kind of police authority.
Right, and then you also allude to the fact that the state is a fiction at best.
Right, it's political, and that they're trying to say that you are physically within the plaintiff. And I think that's an issue of fact. How can you factually be inside the plaintiff?
Okay.
And that's kind of to force them to stop conflating or reifying the state It's more like conflating this political entity, this fiction, with the ground. Well, you're physical. We want them to be able to be upfront and be honest with something, and that is, look, you're physically in Oregon, and that's where we have jurisdiction. We want them to admit that, and so that's why I have that section in there.
Okay. Help me clarify this, Mark, because as far as I can tell, the police officer that's going to be there would be testifying under an expert witness to the validity of the picture and everything else. So as far as I can tell, there is no actual plaintiff that I can redress. Is that something that I need to bring up at some point if they don't allow the MTD?
Well, you want to make sure that you are not confusing plaintiff with witness.
Okay.
The idea that you have a right to confront your accuser. There are a lot of situations where the plaintiff is not the one who actually witnessed the damage that you caused.
Okay.
They may be relying on. So let's say if my neighbor sees somebody break my window or smash my car, I wasn't around to see that. I'm the plaintiff because I've had let's say a legal injury and damage.
Okay.
But it was my neighbor who witnessed it and actually, it's based on his testimony. So it's kind of a patriot kind of thing, or a Freeman on the land thing. Well, where's the state here to testify? No, it was an agent of the state who's the witness, not this legal entity called the state itself.
Okay.
A plaintiff doesn't have, real quick, hold that thought. A plaintiff doesn't have to necessarily appear and testify. That's what we're getting to, so.
Okay.
Unless they're actually witnesses.
Okay, so in this scenario, the witness is the camera, right?
The witness is going to be the camera. It's going to be, yes, it's going to be a picture, and they have to have the police officer to testify to certain things about that picture.
Okay, and that's not something that I would get into?
Oh, well, remember, one of the most important things here is the foundation of the prosecution's case, right? And that sets the relevance for everything else. So we'll talk about relevance when we get back and why you're going to be objecting to the picture being put in, because it's going to be on relevance. And so we'll address that on the other side of the break. Just hold tight and we mute you out. My name is Mark Stevens. You listen to the No State Project here on the Liberty Radio Network, LRN.FM, baby. We'll be back in just a few moments talking about relevance and why it's relevant in just a moment. So don't go away. Second of 3 hours of Anarchy Radio right here on the Liberty Radio Network. And, of course, what we mean by anarchy is an absence of rulers, not an absence of rules. And we believe that the rules, the basic principles, right and wrong, apply to everyone. That just because you call yourself a government doesn't mean that the basic principles of right and wrong don't suddenly magically don't apply to you. And I tell you, one of the reasons why I do the show is to help give people the tools to be effective about defending themselves against bullies. Because I've made no secret about it. I can't stand bullies. So yeah, that's a big part of it. So that people can actually, dismiss this crap that you can't fight Standing Hall. Yeah, you actually can, and you can win. So Nurse Wubbles, I reported last week, and there were a lot of people. She got made a $500,000 settlement against the city of Salt Lake because of the false arrest that former police officer Payne had done. So, which he's appealing at, of course. That's what they do. And remember, if you're prepping for court, one of the most important things you can do with the script is to role play. And so we have about 409 people now in the Skype, No State Project Skype chat. That's the main one. Yeah, 409 of us are in there. Definitely get yourself in there and prep. And somebody who is should definitely be there is our caller from Portland, Oregon, Trevor. Welcome back, Trevor. Okay, we were talking about relevance, right?
Yeah.
Can you tell me what is the ticket relevant?
No, because the question isn't whether or not I was there. The question is whether or not the Constitution and Code apply to me.
So right. So if the prosecution hasn't proven jurisdiction, and can't prove the foundation of the claim against you, this code violations, you violated the code. So if they can't prove that, they don't have any evidence and they don't have a qualified witness. I mean, you know that because that's what we're doing in the motion to dismiss. If they can't overcome that, is anything about the charge, such as the picture, relevant?
It is not.
And that's why I was saying about the relevance before. Relevance is very, it's not a high burden. It's not like beyond a reasonable doubt. It's any tendency of information to prove a proposition or a fact. Does the picture have any tendency to prove that the Constitution, a written instrument, applies to you because of your physical location in Portland?
No, it does not.
And that is something for the prosecution to argue, right? They're trying to get it admitted. So fast forwarding a bit, where if you're in the trial and they're trying to do that, which is a pretty good likelihood, the prosecution's burden is to argue that it is relevant. They have to show a connection. And if the photograph has no tendency to prove that the Constitution applies to you, because disclosure is kind of a sticky thing, because you've already submitted the discovery request, right?
Yes.
So what could the prosecution possibly say to overcome an objection to relevance about that picture? That the picture contains, or that there's other testimony that's going to be given, that there's other evidence that's going to be presented to show the relevance? Well, what could he possibly show other than the picture?
The only thing I can think of is that the picture establishes date, time, and location.
Okay. Which
has nothing to do with the applicability of the law. But I think procedurally they're going to want that admitted as supporting documentation, I suppose.
Sure. Yes. Yeah. And more than likely, it's going to come down to you on the cross-examination. But keep in mind all the things that happened before the cross-examination. All your discussion with the judge and the prosecutor are going to be very relevant to show, to be held over the cop's head when he's on cross-examination. So an example is working with somebody he's been on the show, Eric, and it's something out of Boston. So we had a prosecutor named Castillo that's involved. The judge and the prosecutor may say this to you also, but you absolutely will object, but it really sets the witness up for a big fall. They lie, and they'll say, again, this is very common, well, sir, the evidence is that's what the prosecutor is here to present. It's going to be presented here at trial. And they actually said to Eric, it was in the police report. You're actually being specific with me? And it's like one of the worst things that these people can do. And they hate being specific. But they've got nowhere else to go here. So if they pull this crap on you and they try to say that, look, this is why we are here at trial, is for the prosecution to prove by a preponderance of the evidence that you committed the alleged act.
Right, but doesn't the laws have to apply to me in the first place in order to even have that discussion?
Right. So you want to make an objection to it and say, well, objection. Are you actually stating that the prosecution has not presented any evidence to prove jurisdiction to even have a trial?
Okay. Mark, if I can back up just 1 second, because we were talking about the officer and his quote-unquote expert testimony. In doing that, is that where I should be asking him, what facts or evidence does he rely on that would support their claim? Or are they going to, do you think the judge at that point would say, well, that's beyond the scope of the witness's testimony. He's only here to testify to the validity of the picture and the credentials of the camera.
He may say that. So you have to say, well, objection. Are you saying the prosecution has no witness to support the foundation of their claim?
Okay.
Because if he does say that, I say, well, you have an objection again on relevance. Well, I renew my objection on relevance then, sir. By your own admission, nothing he says is relevant because the prosecution can't meet their burden on the very foundation of their case.
Okay. Do you think that it's pertinent to go through the questions of, am I presumed innocent? Is jurisdiction one of the elements of the crime, and do it that way, or just go right in?
I think you need to go right for the throat. I think you need to stand on the motion to dismiss as far as, but you're asking, has the prosecution met their prima facie burden? Is there any evidence to even suggest that just because I'm physically in Portland, your laws apply to me? That, to me, has proven to be the more effective way to go. There's no way out of it. All they can do is deny you an opportunity to defend yourself and have the judge violate due process and fairness by not holding the prosecution to their burden. And if it's considered civil, you're not presumed innocent.
Okay.
But, this is a big but, the prosecution had to have at least met their prima facie burden. They have to have something on the record, some evidence, some facts, some information that proves the proposition. On the record. Prima facie, again, for those new, is at first glance. Prima facie is evidence or information that, if accepted as true, makes it likely that you committed the act, that you are guilty. Not that you are, but if taken as true. So we'll go through more of this. We're up against the break, so you just hold tight. My name's Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. We'll be back with just a few moments. If you want to join me, instant message me at Frank Rizzo 3. It's Frank Rizzo and the number 3, so don't go away. MarcStevens.net is the website. Check it out, especially if you are looking to defend yourself against these bullies, these killers, thieves, and liars, predators, who call themselves government, who don't believe that who not only don't believe that principles of right and wrong that apply to everybody else apply to them, some of them actually don't believe that the principles of logic don't apply to them, that they can have their own logic. Yes, when you have a prison system, you don't really have a big need for a damn for things like logic and evidence and fairness and things like that. But those with a prison system would have you believe that their rules apply, and they magically don't need any evidence because, hey, they're willing to shoot you. I want to bring back Trevor from Portland, Oregon, working on making sure that he is prepped for court. So what were we talking? Oh, you know what? I didn't write down. Where were we?
We left off at objecting to the witness if the cop takes the stand, that he's not there to the witness to support the foundation of the claim, so object to relevance on that one.
Right.
And then you were also talking about I forgot that last part.
Well, that's all right. Well, let's go back in this situation before the witness is even on the stand.
Okay.
You're going to have to be able to effectively hold the prosecution to their burden of proof and object, appropriately, because what's going to happen is, and I do want to throw out that we did have somebody recently. I don't have all the details, and the only details I have is it happened on the East Coast, and someone did 10 days in jail for asking a question. Again, that's the only details I have off the top of my head. So you have to keep that in mind.
Okay.
In a very small percentage of these situations, the most famous one on the show, the most popular one on the show anyway, is Dick Noble throwing someone in jail for asking a question out there in Michigan. I actually have pictures of him that I've put in some of the videos. So if I do video for this one, I'll make sure I get Dick Noble's, mug in there again. So you want to keep in mind when you are objecting to these two prosecutors, because you'll be able to call the show next week and be able to report that, yes, the judge actually was blatantly prosecuting me with the prosecutor. Okay.
Do you suggest staying away from the who do you represent, and if there's a conflict of interest, would you recuse yourself? Do you stay away from that?
I only stay away from that depending on the temperament of the judge. It depends on how things are going. If you've got a guy with a really short fuse, it's not going to happen, right? Because what I'm saying is you don't want to ever object over what the judge is saying. It's
right.
One thing to object over what the prosecutor is saying. Don't interrupt the judge. So as long as you're not interrupting the judge, he doesn't have any grounds to be threatening you with contempt. And don't buy this lie that you can't object to something that the judge is doing. That's BS. Well, you can only object to what the prosecutor does. No, that's not true. That is not. Does the prosecutor? This is something I want to throw out there, and we'll get back to the point in a second. Does the prosecutor deny you cross-examination, or is that the judge?
The judge.
Right. And is the prosecutor in any way able to stop you from doing a voir dire of a jury?
No.
No. And those are like the two biggest, some of the worst errors that a judge can do. So the idea that you can't object to what the judge does is absolutely dead wrong. If the judge allows someone to testify as an expert and he doesn't have the qualifications, yes, the prosecutor is on the hook for a due process violation. Yeah, but the judge is also on the hook because the judge shouldn't have allowed it. So this idea, and that's the thing too. You have to accept, Trevor, that everything they say is a lie, and your job is what I've said so many times, is just to object and get them to try to verify what they're saying, which is what this comes down to. So to get back, you want to jump right into it. Because you probably won't have the time. This is just a photo radar, so you might have that. So you have to kind of gauge the judge if you're going to be able to do that. Because what happens here is typical. He's just going to lie about what about for the prosecution. So we've already covered one of the most common ones. Like when you're asking for the evidence to prove the foundation of the prosecutor's claim, and the judge just flat out intervenes and lies, saying, well, that's why we're here today, sir. In fact, we have one in Ohio I posted a while back. That remains to be seen. So you already know how to object to that, right?
Well, I mean, other than saying that, okay, well, in order to proceed, don't we have to actually establish that the jurisdiction is valid?
Objection. So your position is that the prosecution has not proven jurisdiction at this point, and you're going to let it go to trial anyway.
And it's been so long since I was in traffic court. The last time I remember is that initially it's me and the cop who has the photo, and he'll come and talk to you first and say, well, this is what we've got. If you plead guilty now, we'll recommend a reduction in the fines and fees. Or you can fight this thing and, potential jail time and bigger fees. So what do you want to do? Try and intimidate you. So don't even bother talking to the cop. Just tell him, okay, you know what, I'm not interested in talking to you. We'll talk to the judge. And then the judge, I think, is really going to have a limited conversation with respect to how we go forward.
I would absolutely talk to the cop.
Okay.
Because if the cop is acting as a prosecutor, he's on the hook.
Okay.
We're up against the break. All right, so I'm writing it down. We'll get right back into this when we come back. So just hold tight. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM. Talking with Trevor in Portland, Oregon, and why it's important when you have an opportunity before a so-called trial to talk to the police or the prosecution to try to make a deal. You got to get some leverage, and you actually could get a good deal. But we'll talk about that when we get back. Don't go away. MarkStevens.net. That's the website. You can get government indicted, also the scripts and the templates. Full model on how to effectively defend yourself against these bureaucrats. So that's what we're talking about right now. We have Trevor from Portland, Oregon. He's going into a dog and pony show called a trial or a hearing. A hearing, yes, the hand quotes, on this week. And we're talking about why it's important to discuss when you have the opportunity to, prior to these so-called hearings, why it's important to speak to the police officer or the prosecutor before. Because if you have an opportunity to make a deal, hey, take it. You want to be able to put them on the spot and give them, because in some situations, it may be the first real challenge they've ever had, and they're seeing just how committed we are to this challenge. We're just not going to roll over and take it. We are going to fight them. And it gives you an opportunity, too, Trevor, to get some of their own statements to use against them in an insurance claim against the city or the county. Actually get their words to use against them. Because, like what happened in Massachusetts, the judge is saying, I know Ms. Castillo. I don't think she said that. And that referring to, she said she didn't have to prove the laws applied. Well, the fact that the judge is not making her meet such a burden, why would it be so difficult for him to believe that she said that when she's taking his lead? Oh, these people. Anyway, right? I like, wait a minute. You're not making her prove the laws apply. That's why she's so confident to go and say to Eric, hey, I don't have to. I don't think she said that. Well, are you going to make her prove it? Oh, no.
That would be silly.
Oh, my gosh. Yeah, she's following your playbook. She's getting ready to be a judge, which is, prosecutors then become judges. And honestly, before we get back into this, why would you want a prosecutor to sit as a judge? Even if we accept the system is valid, these people are so pro-government. Their entire career has been up to that point being pro-government. They have been engaged in an epidemic of Brady violations, which have sent innocent people to prison. Oh, I know what you do. Give them a higher... Give them a higher position. Oh, and throw them even more immunity. The highest immunity that the law has. Yeah, prosecutors don't have absolute immunity. They have prosecutorial immunity. But judges are the only ones in the government that cannot complete civil immunity, these people. All right, anyway. So this is, I would take it as an opportunity and say, look, do you have any evidence? And ask him for the evidence. I have this motion that's pending. Do you have any evidence to overcome it?
Okay. And if his response is, well, that's not the capacity in which I'm going to be operating under.
You're not acting as the well, you have to ask him. So you're not acting as the prosecutor?
No, I'm just here to testify on the validity of the picture.
A lot of times they don't have a prosecutor. Now, that doesn't mean that the prosecution is off the hook, because they're not. But if the cop is not the one who signs, because like in Arizona, there is a police officer that signs the ticket. They are responsible for that ticket. So if they're going to hold that the cop who signed the ticket is not responsible, that still doesn't relieve the alleged plaintiff, the other part of the adversary here. They're not off the hook. Well, you could ask him before he's on the stand then. Well, does the picture actually prove that the Constitution applies to me just because I'm physically in Oregon at the time? And he may say, I have no idea. Okay, so I just write it down. Say, okay, all right. And now you could take that back to the judge.
I'm sure you probably have. Have you ever had when the judge says, well, it's the fact that you're in the state. That's the fact. And that's what means that the laws apply to you. That's something that we abide by. Yeah,
we get that all the time. That was something that I talked about in the first segment or two, where they just repeat it. So I say to them, well, I understand that's your claim, but can you prove it's true? Aren't you just repeating it? And that's how I handle that. They may say, well, I don't have anything else to offer you. So you can't actually prove it's true. You may say, why do you think that's true? You could ask them, can you prove it's true? I know that's how you do things. Isn't that just an appeal to tradition? And we mentioned that earlier. They may not have anything else. It's up to you to then object to them being put on the stand. I object to it even going, say, as far as my motion to dismiss, I've already spoken to him. He's got nothing. Okay. I'd say the common thing, though, for police officers to say here, and this has happened before, and it's always mind-blowing. I don't know why, but they'll say that they'll let the judge handle it.
Right.
It's a level of arrogance that is only exceeded by how comfortable they are in their relationship with that judge. To say something like that, because any judge who considered himself a fair, impartial, independent decision maker should be outraged by that statement. They should call the cop up there and say, I should hold you in contempt for what you're implying here, sir. Can you imagine? Just imagine you did that. What the prosecution would do. Say, the prosecution is, hey, we want to have the evidence that you plan on bringing. We want our disclosure. We sent you the disclosure request. We need the disclosure to be able to be prepared for trial. Where's the disclosure? Oh, I'm going to let the judge handle that. That prosecutor or attorney is going to want to know what kind of relationship you have with that judge to make such a statement like that. I mean, when you change the context and it's not the government prosecutor and a government, judge, you could see just how crazy these things are to say something like that. So the best that they're going to be able to do that I've ever heard is that, yes, they'll just repeat the claim. So you want to ask them before. So you can't actually prove that that's true. All you can do is repeat it. Okay. And so you want to make your objection to the judge, of course, and all objection. The man has no actual proof. All he has is a claim. He just keeps repeating. All right. Well, what else? What else do we need to do to get you prepped? It sounds like you need to do some role playing still. So hopefully you can get with the guys after and do that.
Most definitely, I will. So when the judge is, saying, "Hey, we're just here to handle the plea," you're pleading not guilty, no contest, or guilty. Which one is it? Still try to stay to the motion to dismiss, and has the prosecution met their prima facie?
Well, yeah. If we're at a point where he's denied the motion, mm-hmm. then you can move on to the unsigned plea of guilty if that's what they're going to do. It doesn't sound like they're going to do it, but you move to the unsigned plea of guilty and stay right on that point. But if they're going to deny the motion to dismiss, so let's just say the judge with no explanation whatsoever, you walk in and you mention that there's a motion pending, and the judge says, "Look, I've seen your motion, I've denied it, we're going to trial." What do you? All right, so. All right, we'll get back to how we address the summary denial of the motion in just a moment. So just hold tight. My name is Marc Stevens. You're listening to the No Stay Project. This is a very common one. They just want to say denied. And, man, they hate when you make an objection and ask them about it. But you have to do that. It's the only way to be – you have to be effective. So we'll be back with that in just a moment. Don't go away. Learning how to effectively defend ourselves against these killers, thieves, and liars, these predators who call themselves government, who don't believe that the principles of right and wrong, do no harm, doesn't apply to them. And how to effectively defend ourselves against them despite their violence. Because if they were just violent and they used just threats, people would see them for the criminals that they are. They might actually do something to put them down. So they put on a facade that they're protectors of life, liberty, and property, and that they are providing due process and fairness. And that contradiction, the violence, we bring that out. And so, welcome back, Trevor. We're going to go another segment on this. Wow. Yeah, the show goes fast. So, what we were talking about before, if the judge just says, and he summarily denies the motion to dismiss, which does happen quite a bit, gives no explanation, just says, your motion is denied, we're moving on the trial, what do you do?
That I would ask what the grounds.
Is that an open-ended question, or is that a leading question?
That's a leading question.
Really?
I'm so sorry. That's an open-ended question.
Yeah. So you don't necessarily know what the answer is, right?
So I would rephrase that and say, are you denying my motion to dismiss based on the fact that the prosecution has provided ample evidence to prove the Constitution and Code apply to me?
Or a better way to say that would be objection. So you're convinced the prosecution has met their prima facie burden on jurisdiction.
Okay.
Because the next question is pretty bad if they're going to say yes. So let's just say he says no. But that's what we're here to do. What do you say?
So his answer is no when I ask objection. So you're convinced the prosecution has met their prima facie burden of proof?
He says, no, that's what we're here to do today at trial.
Okay, well, in order to proceed, we do have to establish that the jurisdiction is applicable. So I'm still asking for any facts or evidence that have been submitted to the court that would support that claim.
Is that a question or a statement?
That's a statement.
Should you be making statements?
No.
That's right. You put in the form of a question. So what I like to ask, and we've covered this already, is, so your position is that the prosecution has got no evidence on the record to prove jurisdiction, and you're going to push this to trial anyway.
Okay.
Now, the thing is, the prosecution, let's say he says that, yes, he is satisfied they've met their prima facie burden. He could say that. Your response would be?
Great, can I see it?
Should be objection.
Okay.
Objection, where in the record? And the objection really is you're calling BS. He's lying to you. Prosecution could not have met that burden. The prosecution can't meet that burden. To borrow what happened in New Hampshire a few years ago. Marie Del Terrio, general counsel. If we had to prove that the laws applied in every prosecution, we couldn't prosecute anybody. That's why they say they don't have to prove that, because they can't. And we're not talking theoretical here, everybody. We're talking practical. This is not philosophy, as some may claim. You're talking about an actual written instrument that's real, applying to somebody and creating an obligation. So that's why I would come back and say, objection, where? What are you talking about? What evidence? Where is it? Because you want to keep going back. The only way to legitimately deny the motion, which is based on a lack of evidence, is for the prosecution to have the evidence in the record. Not a trial, in the record right now to overcome the motion. Because even if you wanted to give them some, like if you want to make an assumption that there's some good faith there, and he's not just being a jerk for the prosecution, you would say, but why would you deny the motion now Why, instead of waiting to see what the prosecution has and then denying the motion if he overcomes? If you're waiting to see if the prosecution can make that burden, you don't deny the. Even that. If the look, bottom line, this is so stupid. Bottom line is, if the prosecution doesn't have, and you could say an objection, isn't it consistent with due process to grant the motion if the prosecution doesn't have the evidence right now? Always put. You see how much? Can you see how much more effective it would be with them to ask the questions as opposed to just making statements?
Yes.
Doesn't due process require that evidence of jurisdiction be on the table before you force me to trial? Choose your words carefully, sir, because how you respond will determine whether I sue you. I guess, it depends if you're in a small town because, hey, I want to get a judge just like you who's going to make you go to trial before you can argue jurisdiction. Yeah. Okay, so in the remaining couple of minutes we got here, are there any questions about how and when you should object and why?
Object early, often, and anytime you can.
Yeah, you should have, yes, and you should have, you should have good grounds.
Okay.
And you should be objecting to the prosecutor, what the prosecutor's saying. Big one is he's probably going to be asking what are called leading questions. And leading questions, again, are questions that have the suggested answer in the question. It's not open-ended. It's a yes or no. So when the prosecutor, if there is one, is asking questions of the witness and they ask a leading question, you have to object. You should also be objecting on relevance. Relevant or objection assumes facts not in evidence, or the relevance is a big one. The picture and whether you are physically in Portland is not an issue. The issue is it relevant to proving the prosecution's claim? Which up to now they haven't been able to do. And that's the thing, you may have a whole history there. You may have a few minutes of history of what just happened to be able to use against the prosecutor when he wants to put the police officer on a stand, or if the judge is going to call him, because there is no prosecutor there. No, objection. We've already established that there's nothing relevant for him to provide here today. Nothing. Okay. Okay. So just know too, looking at the time, know that if more than likely the cop is they're going to put him on a stand over your objection. And don't sweat it, because on cross-examination, they're going to just turn around and they're going to deny you effective cross-examination anyway. They're not going to let you talk about those things. He's going to talk about, and somebody is supposed to be there to testify that you violated the law. He's probably going to be saying something like that. And then they're not going to want him to testify to any matters regarding that, as far, on cross-examination. And that would be a denial of cross. So if he's going to deny you cross, don't sweat it. And I do got to throw in there, just know that these errors that you're getting and the objections that you're making, and you need to say objection, are to preserve the due process violations for the appeal, if you have to do that.
So if he starts quoting the ORS in violation, you were speeding and that's a violation of the ORS, whatever it is, object to that, right? Relevant?
Yes, objection. Well, objection assumes facts not in evidence. We've already determined, haven't we, that there's no evidence whatsoever to prove that just because I'm in Oregon, the laws apply.
Okay.
We're unfortunately up against a break. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM. We'll be back with the third of 3 hours of Anarchy Radio here on LRN.FM. Don't go away. Yes, welcome back to the No State Project. The third of 3 hours of Anarchy Radio right here on LRN.FM, the Liberty Radio Network. We have an additional hour commercial-free on Wednesday. It is at No State Project on YouTube. I wanted to point out, somebody had asked if a summary denial of a motion was the same as a summary judgment. No. Summary judgment is when you have a complaint that's filed and a responsive answer, and there are no genuine issues of fact appearing, and so there are just theoretical issues of law that can be determined by the judge, and so because there are no genuine issues of fact, there's no reason to have a trial. A summary denial of a motion is just a scumbag move by the judge when he is so biased against you because you have the audacity to challenge these bullies. How dare you? You're just supposed to, like most people, make a deal and plead guilty and get it off the docket. You're not supposed to challenge them. You have the audacity to challenge them. So anyway, the denial, it comes with no explanation whatsoever. You have a well-written motion. It's pointing out the prosecution clearly doesn't have evidence. There's nothing in the record. There's only the allegation. And the judge with no consideration, no discussion, and here's the big thing, no actual grounds. Just says denied. Sometimes literally rubber stamping, like the tax court. Just denied, denied, denied. Frivolous, 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 denied. It's like the only two words that they know. So that's the difference there. A summary judgment may actually have merit to it. Summary denial typically doesn't. And if they had the grounds, then they would just tell you. Because when they do have grounds, they usually will tell you. They're very happy to tell you and run at the mouth and let everyone know just how smart that they are. Ay, 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 these people. But again, Frank Rizzo 3, instant message me, and we can get you on the broadcast. But before that, we got Brett from Northern Ontario up there in Canada is joining us. Welcome to the show, Brett.
Can you hear me?
I can, loud and clear, eh?
Thank you. How you doing, eh?
I'm doing fine.
Good. Thank you, Mark, for taking my call and helping me today.
Well, I hope that I can help you. What's going on?
Okay, well, I have a pretrial on Monday morning. This is my 5th arraignment on a marijuana charge. I have a prescription for marijuana, and I was pulled over, and they caught me with a pound, and they charged me with trafficking. And that is it. No personal possession, nothing, just trafficking.
So you want me to believe that the Canadian police are charging they're charging you with a pound of weed instead of half a kilo?
You've got it.
That's interesting.
Sorry, half a kilo. You were saying you got it, yes.
Oh, okay. All right. All right. I thought that was a little odd because it was Ontario. Yeah. Okay. 5th. All right. So it's pretrial, but you said 5th arraignment. So are they going to do an arraignment and then immediately go to a pretrial?
They said at the last arraignment that they wanted to do it. The prosecutor was trying to waive all arraignments and just go right to trial.
But,
and then the judge stood in and said, excuse me, let's give this guy a pretrial first. They were trying to do me without KY.
Yeah. So much for everyone being so nice and polite up in Canada. So tell us why in the world would you have 5 arraignments so far, or at least 4?
Well, okay, my first appearance, I didn't accept jurisdiction. I saw a lot of this common law and I guess law, free man of the land and sovereign citizen. I've seen a lot of that movement, and then I saw your movement. So yesterday I wanted to narrow that down, and I was given some very good information to drop the sovereign citizen altogether, which I've done. I've got to, anyways, to answer your question, to narrow it down, what they were asking for on my first appearance, they were asking for my documents. So every time I've come back, they've asked for another document. Oh, can we see that prescription in writing? Can you get more documents and whatever else? And we'll dismiss it next time and whatever else, And they've kept asking me, to accept a lawyer and to accept, legal aid, which I won't.
Okay. Well, hopefully the sovereign citizen Freeman stuff, did you file paperwork, or this was just things that you said?
No, just things that I said. I have to file my motion to dismiss from your site. I will get those papers off your site before Monday.
Okay. Yeah. You've got to stick to just basic logic. You know that they, even in their system, the prosecutor bears the burden of proof. You've got to hold them to it and only challenge what they're presenting. And, of course, like we always do, the threshold issue. The threshold issue, the foundation is you're physically in Ontario. Our laws apply, eh?
Yeah, where's my jurisdiction? That's
yeah,
right.
Radically different than this other stuff.
Yeah, no doubt.
That you mentioned because, hey, I've mentioned on the show, poor Frank out in Saskatoon, he was convicted of, without a trial, of tax evasion. He was charged with a crime. And which his entire trial, I'm not making this up, I have 2 people that reported this, including Frank.
Mark, we hear crazy things.
But he was convicted without a trial. All the judge accepted was a bound copy of Meads versus Meads.
How is that a fair and meaningful anything whatsoever?
I know. I figured, well, the appeal's got to be a slam dunk on this one. Wow. I mean, even if Frank was raising the stuff, the issues, the legal conclusions or the legal interpretations that is in Meads versus Meads, you still have to put him on trial if he pled not guilty. Exactly. Oh, so okay. Well, I'm glad.
Pleading innocent. What about pleading innocent even?
Well, they'll just accept that as a not guilty. So the innocent really comes in when they put you in prison and DNA evidence exonerates you.
Yeah.
But so all right, let's get back to this. All right, so with no more, we're gonna wipe the slate clean. Hopefully, you have not prejudiced yourself bad here. So when you start doing it where you're actually trying to hold the prosecution to that burden, the judge will be just as the way he was before when the prosecutor wanted to skip the arraignment and just go to pretrial. So
that's right.
You need to get in because they are required to give you all exculpatory evidence and information. Also in Canada, just as they have to here, we just don't call it Brady in Canada. So you need, with the motion to dismiss, comes with a discovery request, which is written for Canada. Perfect. And what day is this happening?
On Monday morning.
Monday morning. So I trust that you've already gotten started with the role playing in this.
Oh yeah.
Okay.
Yes. Yep. I was actually given some very good advice. Your 3 segments. The one, my intention to make an informed guilty plea today. 2, threat of violence, the gun in the room. That's why I'm here. I don't want to come back. We need to deal with this today, right? And then number 3 would be the prosecution's failure, to bear the burden of proof of jurisdiction in any way. And so if they keep going, oh yeah, you're here today. You've got a driver's license, so that's jurisdiction.
Okay. Well, we're up against the break, so just hold on a second. We'll continue with that driver's license crap. Yeah, we get that all the time. You mentioned something that's extremely common, something that they do, and that is to throw out something like you have a driver's license, and that's the jurisdiction, right?
That's right. Yep.
All right. Well, in what you've got to know so far about the way we do things, if they make a comment like that, and it doesn't matter which one it is, it's the same stupid thing whether it comes from the prosecutor, and they tend not to say anything anyway. It tends usually just to be the judge that's doing all the talking. But how should we respond to such a claim?
I would come back and say, well, Your Honor, I have no choice. I had no choice to feed my family. I need a driver's license.
Well, I wouldn't say Your Honor, first of all, because I think when
my bad, yeah.
Yes, sir, or no, sir, or ma'am, that's what I would do. I wouldn't say. I would say Objection. So it's your position that the driver's license, which is compulsory, is somehow evidence proving your Constitution applies to me?
Yeah, exactly. Objection, point of clarification.
Or yeah, and so what if he says yes? What do you do? What do you do with that?
Go back to my second segment. You know, I was threatened under violence. Well, I would be if I didn't have a driver's license. If I was driving without a driver's license, you know, I was coerced into getting one. Would be.
Well, you could also say, oh, so if I didn't have a driver's license, the court would have no jurisdiction over me. Well, and of course they would say, well, okay. So since the prosecution, you still would have jurisdiction, the driver's license really isn't evidence of jurisdiction, is it now? I also like if they say something stupid like that, they actually make such a stupid admission. I like to come back and say, oh, well, objection, I'm a little fuzzy here. Exactly how does forcing me to get a driver's license prove the Constitution applies to me?
Well, it just does, sir. You know, that's what they tend to do, right? So then what do I just keep going back to that? You know, so are you saying, for the record, you know, objection, are you saying that, you know, a driver's license means that you have jurisdiction over me?
I think if they say something in court, and I'm pretty sure they say it, but most of the time I remember hearing that is outside of court. If they say something like that, you've got to hit them right where they breathe. So, objection, I'm a little concerned for my safety now. Is that the standard that this court holds? It just does?
Exactly, yeah. Yeah.
How this? Yeah. It typically doesn't come out in court because they're trying to put on a facade of legitimacy there, that there is a burden of proof that the prosecution has them. They'll tell you that. And to say it just does, no, out of court, if the prosecutor's talking to you at a pretrial conference or a case management, they may say something like that outside of earshot of the judge. In court, yeah, not so much, but we know how to object and follow that up if they say something like that. They probably will say something, well, we're not going to get into that right now, sir.
Yeah, and that's where you're a shark. In every video I've seen, you're the best at that. You know, you raise the question, you question them back, exposing their facade, exposing their ridiculousness, you know, without becoming rude or angry or getting off topic. Joe had mentioned, you know, keeping my pen on the one segment or one softball question until they fully answer it, no matter how much they try and deter me off of my question or, you know, or their answer. You know, just wait for that yes or no and then come back with the question like you said, you know, and re-question. Yeah. Just for the record, point of clarification, you know, you're saying...
Yeah, you have to keep them on point, and it will upset a lot of them because you're not allowing them. So, and you know, imagine that you're asking. This happened to me. It wasn't even a bureaucrat. It was one of the worst examples of diarrhea of the mouth I've ever experienced. It was supposed to be a so-called debate. It wasn't. Years ago with Clint Richardson, and I had asked him a leading question, which just required a yes or no.
Yeah.
I think, you know, a week later, he stopped talking. And all I said was...
Sorry. That was just like the judge last time, man. He went on some sort of rant about, oh, God, I don't even know. He started talking about his kid in kindergarten. And I said, how is that relevant today? Like, I asked for a yes or no question, by not your life story.
And what I had said to Clint after that long dissertation was that a yes or no to the question? Yes. And he's just, what question? Yeah, you see, this is why we call it the Gish Gallop. You know, there's a reason why we do that. I don't throw that particular one out too often, but when it's appropriate, you gotta. So, that's why leading questions are so important. So look, it's just yes or no. to get back to this, Hanks is he says, why is the judge making declarations for the prosecution? That's what the judges do. And yes, we have to object as to why the judge is answering for the prosecution. The judge may have an excuse. He's doing that based on the record, but objection. Can the prosecution please prosecute their case? I want to know, do they have the evidence, yes or no? But you're at pretrial, so I want to get to, again, and reinforce just how important this is. This is the opportunity, and this is the time for the prosecution to put everything on the table. Yeah. To inform you so that you can defend yourself or make a deal. But they have to put this on the table, and yes, exculpatory evidence has to be presented. We're up against the break, so let me put you on hold. Hopefully we don't lose you again. We'll be back here with Brett from Northern Ontario in just a moment, so don't go away. And so someone on Skype is asking me, hey, Mark, can you take a minute to explain why you chose Frank Rizzo as a Skype name? I mentioned this before. It is from the Jerky Boys. I have a very juvenile sense of humor, so that kind of thing really appeals to me. And I remember back on Long Island years ago when they were just cassette tapes that were copied and people gave them out. So I was, a teenager, and I thought the Brett Ware one. I still think Brett Ware would be the best choice for president if we need to have a president. So, yes, I am aware that the Jerky Boys use Frank Rizzo because the attitude of that particular character is very similar to the bureaucrat. So, yes, listen up here, Jerky. Open your ears, jackass. So, yes, it is a Jerky Boys reference. I do want to point out, too, before and we'll bring Brett back up, usually when the judge is making declarations for the prosecution, not only is this unfair because the judge should not be doing that, but they make it even worse because they're aiding the prosecution. They make it worse because they're usually doing it by also making statements or claims that are outside the pleadings, such as in tax cases where judges come in and insist that you're a citizen of the United States, and there's nothing in the pleadings about that. As if that were true, which it's not. Nobody could be a citizen of the United States. It doesn't exist. Or a citizen of a state. Just doesn't exist. So glad that we're able to point that out. So, Brett.
Berg, give me your order.
Say that again?
I said, Burger Bob's, give me your order, tough guy.
There you go, Jerky. All right. Okay, so
we were speaking about the driver's license and how they were trying to prove jurisdiction. How they can say, oh yeah, well, your driver's license is just jurisdiction. So, and then me speaking about that being unfair and speaking about the threat in the room.
Well, right. Okay. I had written that down, but we already addressed how to respond to that. Already.
Yeah.
So, usually what they like to stick on is you're here, which we've already covered this show. Which is, I understand that's the claim. I want to know if there's evidence to prove it's actually true. Why does the prosecution believe their claim is true? Where is the proof?
Yeah.
I'm not saying that you necessarily have to go in and say, objection, proof by assertion, fallacy. No, but you can say, objection, he's just repeating his claim.
Absolutely.
And I think that's a valid objection, to make.
For sure.
Because it comes down to what we've said so many times, what's probably going to happen is something that Trevor has to keep in mind also. They're going to say something like the prosecution doesn't have to prove that. Now, are you aware that that's something they actually say?
Yeah, that would be that's part of their facade, right? They try and say anything, they'll try and. Am I right?
Well, yeah, they'll say some pretty stupid things. And
so I just have to say, objection,
Well, and what now? If he says that the prosecution doesn't have to prove that, and it's literally the foundation of their case, they have no case without it. There's none. The court doesn't have jurisdiction, and they couldn't possibly prove their claim. And if the judge comes out and says that, what are you going to do? What are you going to do there, tough guy?
I would come back and say, is that not a massive demon conflict of interest? Are you not? How are you claiming that a driver's license or lack thereof? I guess I would come.
No. We've already crossed that bridge.
Sorry,
We're going strictly on that you're asking for evidence proving the Constitution and Code apply, and the judge is saying the prosecution doesn't have to prove that the laws apply.
Then how is that a fair and meaningful trial? How is that fair in any way, right?
Sir, this is the procedure. If you don't understand it, you can get a lawyer to explain it to you. You see,
yeah, no, sir.
Yeah, because because you're allowing him. You're taking your eye off the ball. And the important thing here, or the more effective objection and question to ask is,
if I got a lawyer, would that prove jurisdiction?
No. He's saying they don't have to prove that. So what he's actually saying to you in plain English, is, listen here, jerky. I am going to allow him to argue against you without evidence. So the objection should be so that you understand how things are going so you can effectively defend yourself here is objection. Are you allowing the prosecution to argue against me without evidence? Exactly. These are some pretty standard things that we go through because we're dealing with the same, whether it's Ontario or it's Saskatoon or it's Tampa, Florida, or it's Sussex, England, or Brisbane, Australia. It doesn't matter. It's all under the same, it's the same process. And they're trying to make it out that it's fair. Well, if it's fair, are they going to allow you the same privilege of making an actual legal claim against the prosecution with no evidence? You think they're going to let that happen?
No way.
No. And that's the thing. It's the foundation of the case.
Yeah, exactly.
And I'll keep repeating this because we get new people all the time, and I do appreciate it. It's turnabout. Okay, and so the reason why you and I can't argue without evidence is exactly why the prosecution should not be allowed.
Exactly.
It's not fair. You cannot defend against a baseless charge like that.
Straight up.
Because your job and my job is not to go in there and present a mountain of evidence. We don't need to unless there's a mountain of evidence against us.
Yes.
We need to show that they don't have the evidence. And so by pointing out that they're arguing without evidence should get a better response than he doesn't have to prove that. And that's why we're going to counter. We know that that's a contradiction of the rules, right?
Yep.
How do we bring that out? We bring it out by asking a question. Am I going to be able to argue against the prosecution without evidence? No, absolutely not, and we will hold you in contempt. Objection. Tell me why I can't do that.
Yeah.
Just tell, because then what are they going to do? Are they going to come out and say that this particular legal conclusion is irrefutable and must be taken on faith?
No.
Because even in Canada, I don't care where it is, an irrefutable claim has to be violative or violate due process and basic principles of fairness for no other reason than you cannot defend against it. And if you can't defend against it, it's not fair. So imagine them actually coming out and in not so many words saying the entire foundation of the prosecution's case is unprovable and you can't challenge it. Wow. That's what they're saying. When he says he doesn't have to prove the laws apply, that's what he's saying. It's not provable and it's not fair. You're in the rigged game. Tough luck. We're up against the break, so we'll be back in just a moment. So just hold on, Brett. Yes, welcome back to the No State Project. Unbelievably, in the last segment of the big show, so I do need to remind everybody, and I know it's in advance, but hey, I'd like to see everybody out there. We're doing Libertopia again at Humphrey's Concerts by the Bay and Hotel on Shelter Island, and it's a damn nice venue. It's such a nice area. Yes, it's California, but it's so nice. I keep going back. So it's 2303 Shelter Island. It's going to be May 3rd to May 6th, 2018. So there's plenty of time. I'm going to be actually practicing my butt off. I'll be playing bass and guitar out there, so it should be a lot of fun. So go to libertopia.org, libertopia.org, and get your tickets today, jerky. And don't have me come down there after you eat a tough guy. All right, that's my Frank Rizzo imitation. So bring back Brett.
Hello there.
You're at a pretrial conference. What do we do if the prosecutor says they don't have to? See, I want to bring it back. It's kind of, you're going to respond kind of the same way, just without an objection, if you're just talking with the prosecutor. So I would handle it the same way at a pretrial conference if it's just you and the prosecutor, and write it down. Write it down. So I'm going to write down what you're saying because I want to quote you directly. You can argue. You can argue against me without evidence, really. And okay, and does it follow that you obviously would not have a qualified witness? So you don't have a witness with personal knowledge of any evidence at all that your laws apply to me.
Yeah, that's brilliant.
Because logic dictates, and I would say this to them, I say it all the time. So if you can't prove that the laws apply, you can't really prove beyond a reasonable doubt that I violated it, can you?
Exactly.
That's kind of the way logic works. Like I've used examples here before, like if I'm being charged with violating the rules of the Olympics or the NFL, the National Football League here in the United States. Do the rules apply to me in the first place? You can't challenge that. Hey, seriously, Brett, where else but with these narcissistic criminals could someone get away with saying that?
Only in the synagogue of Satan, a.k.a. in the courtroom.
Yeah, the Church of the State with their exalted priesthood sitting 4 feet off the floor, and everyone has to stand up when they walk in.
They want me to hire an attorney paid for by the state or by the province that is the same member of the same bar, the same secret society, or whatever you want to call it, that they all belong to, and then they're going to expect that it's a fair and meaningful trial, or a fair and meaningful hearing, and that it's not going to be a conflict of interest. When they say in the courtroom, well, I've spoken to my friend here, how are they even allowed to talk like that in the courtroom still? Well, my friend here, the prosecutor and the lawyer, like, cut the bullshit, guys. So, sorry about my language.
That one's not too bad. Well, look, they get away with it because they can. I'm stealing a line from Ernest Hancock of Freedom's Phoenix, declare your independence. We have to object to that stuff, of course. What's worse, too, well, I guess it adds to just how bad it is. And people think that, well, there's different branches, and they're on the same team. That's all that matters. So, the judge, the prosecutor, and the cop are all on the same team. And it's, to me, it's mind-blowingly stupid to say, but the judge is the judicial branch, and the prosecutor is the executive branch. They're on the same team. Like, what's the analogy I've used before with like football? Like, whoa, dude, they're on the same team, but they're clearly not working together. One is the offensive line, and the other one's the defensive tackle.
Exactly, like the Conor McGregor fight. Like, they had the boxing coach from Mayweather's team, training him for 3 weeks prior to the fight, and then if they're going to think that that's not a conflict of interest. That's crazy. They have him they have him, training McGregor, and they think that that's going to work. It's like it's absolutely insanity. It's crazy.
We know from personal firsthand experience that I have had, and many others that are called into the show and report this, that the judges absolutely are working on behalf of the prosecution. It's Pankster. Why? It's a common question, and it's kind of rhetorical because we know why are the prosecutors always standing mute? Why aren't they saying anything? Unless it's an opening statement, unless it's an objection during a cross-examination, they don't say anything. And I have proof of this. Ian Freeman of Free Talk Live, when I did that hearing, that is direct evidence of Michael King, the psychopath Michael King, prosecuting on behalf of Gene Killam. It's right there in HD video, I think. Well, it's on video for anyone to see. She didn't say a single word in her own defense for damn near an hour.
That's just like this clown Joseph Chapman here in Northern Ontario. He showed up to but one hearing, and he called me very first up. And as soon as I was in the bathroom. They gave me about 5 seconds. They called me on the loudspeaker. I took 2 seconds away to go to the bathroom, and that's when he called me. And then he left. And then he left the building for the end of the day. So at 5 o'clock, they brought my name up again, and then the duty counsel, that's what they call it here.
Duty.
He comes up to me and he says, are you sure you want to address the court today, or do you want to just put this off? And that's when I knew, this is up, man. I know exactly what they're trying to do here.
Yeah.
So I took the next date in hopes of watching your videos again and doing some more role playing. And getting far more prepared, and I'm so glad that I have. Because going in there ill-prepared, you're up against. You might as well go to the hospital and tell them to take an organ.
Well, Matthew from Brisbane, and thanks, mate, for this. He says the judge is the middle finger. He's the middle finger on the left hand, and the prosecutor is the middle finger on the right hand.
Exactly.
The state-appointed attorney is unwashed genitalia, so what is that? Well, they are on the same team, and there's no doubt whatsoever. So
if you ask them who they're paid by, what are they going to say? If you say, Judge, are you not paid by the same team as the prosecutor? What will he say?
Yeah, and even more to the point, which is not something we tend to get into because we don't all the time. But if you have, and you can, is you ask him who, even better than who's paying you. On whose behalf are you acting today?
That's right. That is excellent.
Cuts through all of it. It cuts through it all. So yeah, they are working together. They are trying to prosecute you. That's what they do. But we have to still make our objections. We don't talk over the judge like I've mentioned before. You have to remain calm and professional because in the long run, it's only going to help you, especially if you have to do an appeal. You don't want them to say that the guy was just arguing that, without cause. He was he was just interrupting incessantly. You want it to be that if there's anything in that transcript to show that the judge was interrupting, that used that. So our objections. So here, let's get to this because if it's just a pretrial, you have got to hold this prosecutor's feet to the fire every step of the way. Look, and tell him, if you haven't already, I am more than happy to plead guilty and talk to you about a deal. I will plead guilty today. Do you have this evidence? Can you prove this? And if he says something such as, I don't have to prove that, you know how to respond. You can also say, if you had to, can you? Is it? So you want to then to be specific as, is it something you can prove but don't have to, or is it something you cannot prove and therefore the judge is letting you get away with it?
Yeah. Would I be allowed to prosecute without a claim?
Without facts to support your claim. Yeah, absolutely.
Without evidence, am I allowed to just walk in and prosecute you without a claim, sir?
Yeah. Can I make accusations against you without any proof? Yes or no? And why not? And that you use his answer against him. We're actually completely out of time. My name is Marc. I appreciate the call, Brett in Ontario. My name is Marc Stevens. We'll be live again on Wednesday, so tune in for that. So till then, salud.